Welcome to the Assembly Committee on Government Affairs, the happiest committee in the Nevada State Legislature. Will the Secretary please call the roll?
Assemblyman Carter.
Present.
Assemblyman DeLong.
Present.
Assemblyman De Silva.
Here.
Assemblywoman Duran. Assemblywoman Gonzalez. Assemblyman Gurr. Assemblyman Hibbets. Assemblyman Koenig. Assemblyman MacArthur. Assemblyman Nguyen. Assemblywoman Taylor. Assemblywoman Thomas. Chair Torres.
Thank you, and please mark Assemblyman Nguyen absent, excused, and present when he arrives. Welcome to the audience here in Carson City, those joining us in Las Vegas, and those listening over the internet or over the phones. I know we have several individuals set to testify today on the phone. Just a couple housekeeping items before we begin. Please remember to silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. For those joining online, please be sure to mute your microphone when you are not speaking to minimize any background noise. When testifying, please turn on the microphone and clearly state your name and affiliation, if any, for the record. Then turn the microphone off each time you're done speaking. Handouts should have already been provided to the committee staff. We expect courtesy and respect in our interactions. Please remember, just a little bit of sugar helps the medicine go down. Committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. Public comment will be taken at the end of the meeting. Each person will be limited to 2 minutes. In addition, the public may submit written testimony to the committee up to 24 hours after the hearing. We're going to go ahead and go in order with the bills today. So at this time, I'll go ahead and open the hearing on AB 225, which revises provisions governing the confidentiality of certain personal information of members of the military. And committee members will note that there is a conceptual amendment. We just have some of our staff is out this week. So I apologize that it was not given to committee members earlier, but there has been a copy provided on your desks. Assemblyman MacArthur, you found yours? You look a little confused. He found it. That's good. All right. So, Assemblyman Newby, when you are ready, you may begin.
Thank you, Madam Chairwoman, and esteemed members of the Assembly Government Affairs Committee. Thank you for inviting me to present AB 225 before you today. AB 225 stemmed from a simple conversation I had with a constituent. Although I have known this person for years and knew the nature of his military service, I did not know until that day that he personally had been publicly identified by the Islamic State of Iraq and Syria, or ISIS, as a target for elimination. This listing on the so-called kill list stemmed from a mission he and others undertook against ISIS leadership several years prior. At first, honestly, I thought he was pulling my leg. Surely, ISIS doesn't go around identifying individual service members to be killed by their supporters. But I did some research on the issue, and I discovered that indeed, ISIS uses a closely related organization, the United Cyber Caliphate, or UCC, to find the identities of service members and publish them on a so-called kill list. I've submitted a couple of articles about this phenomenon for posting on Nellis in case you want to read up on it. Unfortunately, because of the staff being out, I don't think you have access to it, but I'd encourage you to go back and look at it at a different time. It truly is breathtaking. That's where the idea of AB 225 came to me. Surely we could do something to protect these service members who have put their lives on the line to protect us. But since that time, I've been able to work with Chairwoman Torres, various county recorders and assessors, and the Secretary of State's office. I recognize that there are a number of bills before you in this committee, in this session even, to expand on the list of possible confidential members. And looking at all of those expansions, I have developed the conceptual amendment before you today, which I think would provide the protection that I was intending with AB 225 for this constituent and others like him, as well as others who may be under threat. So with that, if you don't mind, Madam Chairwoman, I'd like to go over the conceptual amendment. So again, apologies for this not being up on Nellis in advance, but the first concept is to strike the current language that specifies members of the military and replace it with language allowing any other person who can substantiate a threat to themselves or their families to submit an application to the courts for approval to make their information confidential. This is essentially to, as it says, allow for this constituent that I was talking about, but also others, to essentially prove that they that they need this protection.
And I'll just quickly let the committee know that the amendment has been posted on Nellis too. So if any member of the public is looking to review the conceptual amendment, please review it on Nellis.
Thank you, Madam Chairwoman. The second bullet is to allow counties who already have these confidential situations or individual property owners on their books to have the option to institute essentially a expiration of that. As we know, there's a long list of people who are already on this list. Some of them may not be in the service that they were in before that made them eligible for this. Some may have passed on. There are any number of different situations where their status could have changed. So this allows counties to essentially expire that status if they so choose. In my discussions with various county recorders, that I will tell you that some are interested in this option and some are not. So that is why I made it an option for the counties. The next two bullet points actually came to me by Ms. Kaylee Work, who I believe is the recorder in Washoe County. And both of them made sense to me. I believe that she worked on these with the other recorders in the state. And so that is to make the list of eligible persons uniform across a number of different Nevada revised statutes so that there's consistency for them to follow. And then adding the section to 247 that may allow the court order to specify that subsequent recorded documents may be redacted pursuant to the active court order. So if you already have this in place, the confidentiality for yourself, my understanding is this would then, if there are subsequent documents, that those would also be confidential pursuant to the original court order. So those are the conceptual amendments to AB 225. What I'm seeking to do is to provide protection for individuals and instead of, and allow that method to happen without necessarily adding entire categories of individuals to the list in the NRS. I'd be happy to answer any questions. And I also understand that a Secretary of State may have an amendment to this, which I consider friendly, and I am happy to keep on working on it.
Thank you. And thank you, Assemblywoman Newby, for bringing forth this bill and working on this conceptual amendment. I will note for the committee that, obviously we have seen, I think there have been over 5 confidentiality bills that have been introduced that have been referred to our committee this cycle, and there's still more on the Senate. So there is more than 5 bills this cycle that have to do with confidentiality as it pertains to the public information. And so I think, as I worked with Assemblywoman Newby and I reached out to you so that we could kind of figure out how we can kind of make this more concise so that we don't continue to see 10 bills every legislative cycle that have to do with confidentiality. So I really appreciate your work on this and getting stakeholders together, and I know that there's probably still more work to do on this. At this time, I will go ahead and take questions from committee members. I'll go ahead. I see Assemblyman Thomas. Anybody else? Assemblyman Carter? Okay, Assemblyman Thomas.
Good morning, and thank you, Madam Chair. And thank you, Assemblywoman Newby, for bringing this bill forward. something that, I think that we want to make sure that no one falls through the cracks with this. My question, and I look at it as a former military member, is this directly for, I know your conceptual amendment says basically any other person, but you started it off with a military member. So is it still for active duty military members or all military members, or scratch that and just any person?
Thank you for the question, Madam Chair, to you and through you to Assemblywoman Thomas.
Feel free to go directly to the member.
Thank you. Assemblywoman Thomas, I choose option number 3, which is essentially that the individual that I was speaking of would be able to take the information that he has been provided by the FBI about him being on this kill list, and then take it in an application and get that protection. So with the conceptual amendment, no longer would all active duty military or guards people be included, other than if there was a threat against them, then they could pursue this avenue.
Thank you, Chair. Okay, so for clarification, if there is a threat, regardless of your military service, as a citizen or veteran, if there is a threat, I would be, or anyone would be able to take that to the recorder and have your personal information removed from the system. Would that also include, because if you own a home, that information is accessible to anyone?
That is correct, Assemblywoman Thomas. It would allow someone to provide that information, not actually to the recorder. First, it goes to a court. There's an application to a court. The court makes a court order. Then that is what gets taken to the recorders of the information. So, yes.
Thank you. Assemblyman Carter.
Yeah, thank you for the presentation. And this kind of ties into what the chair brought out about the proliferation of carve-outs. And, I struggle with the concept of super citizens. Our country's based on equality. And I wonder at what point do we switch from carving out specific individuals to looking at the bigger issue of what data is acceptable for our government entities to release and or profit from by selling. And so I'm struggling with this a bit, and if you could address that a little bit, because doesn't everybody deserve a certain level of privacy, but we also have to balance that with our open society?
Thank you for the question, Assemblyman Carter, and I tend to agree with you. Unfortunately, I think we're in a time in which it has become acceptable to attack individuals, whether virtually or in person at public meetings. We are in a time where doxing and swatting is a thing. And I don't remember in my lifetime before maybe the last 5-7 years where that was a thing. And I agree with you in this whole term that in the super citizen, concerns, because I too have those concerns. If it were up to me, I would probably advocate for all of the names being taken out. But I know that, just as you mentioned, there is a balance between public's right to know and protecting people. So what I'm trying to do with this amendment is to thread that needle and try and provide protection when it's needed, and but still remain as open as possible.
Thank you. Assemblywoman Taylor.
Thank you, Madam Chair, and thank you to our colleague, Assemblywoman Newby. My question is surrounding the opportunity, I guess I should say, for others, whether they're, elected or military, whomever, to go and have their information protected if there's been a threat. I'm wondering if that extends to social media. I had a time not too long ago, a year or two ago, when my personal address was put on social media with "let's drag her out of her house" kind of a thing going on. That's a real thing, and I was unable to protect my private information, but that was scary. That was real. It actually happened. So I know there's a difficulty drawing the line, as my colleague Assemblyman Carter said, but there is a very real reason why we should have the opportunity to protect our information, especially as those who may be targeted. So does that include social media?
Thank you, Assemblywoman Taylor. This does not include social media. This is only the information that would be publicly available through the recorder clerk's office. But to your point, I completely understand the fear that comes. Just as a personal aside, many of you know that my husband is an attorney with the Attorney General's office, and thus he is part of law enforcement. And when he was defending the state, which was his job, in COVID cases brought against the state for the closure of churches, and then subsequently for the election cases, we received messages through social media, things like "your children, you and your family are going to burn in hell." And that's scary to have someone who, we all volunteer to do this, we all come into this building, so there's a certain number of slings and arrows that we are all going to take, and we sign up for that, but my kids didn't, and so I understand where you're coming from, and I wish there was a way to prevent that, but this bill doesn't do that.
Thank you, Chair. I guess I would say if someone threatened, like in my case, they sent the threat via social media, is that enough of a threat to say, hey, here's a threat, and I'm applying for this privacy?
Assemblywoman Taylor, thank you for that question. That would be up to the judge, but I would certainly, if it were me, I would turn that in as an application.
Okay, thank you. I appreciate that. Thank you, Chair.
Thank you. Assemblywoman Gonzalez.
Good morning. I have to see over Assemblyman Wynn's head there. Good morning. And thank you so much for the presentation. I kind of had a few questions, kind of dovetailing off my colleague there. So I'm just curious, because we've now opened it up for anyone, right? And so how would this play into the current processes for, let's say, like a protection order for domestic violence, for example? Could a partner threaten me, and then I could then take this information to the court to seal where my current address is, and or maybe possible new place? Would this be creating more processes for a person? And if this is not if this is not the correct process for someone to do that, what guardrails are in place to be like, hey, this isn't actually the process that you need to go here? Thank you.
Thank you, Assemblywoman Gonzalez. I think I'm not so familiar with the protection orders, but the way I've written this, my intent was if you have been threatened with something that you feel is credible, you can make application to have that information kept confidential. Now, Unfortunately, and I think this is something that you've kind of pointed out in your question, maybe you didn't mean to, but what needs to happen first is that there's a threat, right? It's not proactive, it's reactive. And so, yes, you would need to take that information. I'll leave the question about how that interacts with a protection order up to the court or up to people who are more educated in that area than me. But yes, to answer your question, I would believe that that situation would apply here.
Thank you, and I just have a follow-up. Thank you so much for that. So I know the intent here is to protect people that are receiving threats, but I guess my worry or concern is for it to be used in the opposite way, so for a perpetrator to then use this process against someone. And this is a question, I don't know, like, would it be used like, hey, this person was threatening me, I went and obtained an application, the judge said no, like, would it be part of evidence? Would it be, I guess I'm just a little nervous with opening up to everyone. And then my other question is, what constitutes a threat? In Assemblywoman, wow, I am blanking on her name in my colleague's question, her last name, Taylor. I didn't want to say the first name. In Assemblywoman Taylor's question, right, a social media post would not be considered a threat. So my question, now she's showing me her nameplate for those that can't see online. And so I guess my question is, like, what constitutes a threat that would meet the threshold to then be able to go and apply for this process? Thank you.
Thank you, Assemblywoman Gonzalez, for the question. The part one of the question, I don't think I know the answer to. Part two, I think with, what constitutes a threat, I think that needs to be potentially worked out. Right now, it goes before a judge, the application, and the process is, are you a police officer or are you a judge? Yes, you are. Okay, approved. In this case, there would be some sort of supporting evidence, and the judge would need to make that call. In discussions with some of the court representatives, they may want some sort of standard to compare it to. With this conceptual amendment, I don't have that, but I am more than happy to work on this and continue working on it so that we get to that if that is desired.
Thank you. And I think those are good things for us to kind of be cognizant of. And I will say, as the Assemblywoman noted, I had early conversations when we looked at some of the other confidentiality bills with recorders, and they, to their knowledge, and with the counties, to their knowledge, there weren't any cases that were not recognized. So this at least puts some type of level where it has to be, they have to show that they can substantiate a threat. I might consider in the amendment looking at some type of burden of proof too, so that there's like the requirement that there is something available instead of just like he said, she said. I think it would also be helpful, likely, for the judges to make that decision as well. Assemblywoman Duran.
Good morning, and thank you for the presentation. It is needed. People are crazy these days, so some people make those threats, and sometimes you don't take them seriously, and things happen. But my question is this going to be limited to one property, or would you have to file if you have multiple properties that you own or areas that you live in or states and stuff? Would you have to apply separate for each location?
Thank you for the question, Assemblywoman Duran. This is obviously for Nevada only, so I would imagine if you have multiple residences in Nevada, first of all, good for you. But I imagine that you would have to then go to the county recorder for each of those properties. So for your lake house, you would need to go to Douglas County, and for your domicile, Clark County.
For the record, I only have 3. This building, the little apartment that I live in over there, and one in Clark County, so thank you for that.
Thank you. Members, any additional questions? Assemblywoman Hibbets.
Thank you, Chair. Just a clarifying question on the third paragraph of the amendment, where it says, make the list of eligible persons uniform across the 3 different NRSs that are affected. Is the intent to basically make, so for instance, I'm listed under 25140, but not under the other 2, my personal circumstances. Would be the intent be to list each individual category from the 3 of them and make sure that the full amount is listed in each NRS?
Thank you for the question, Assemblyman Hibbets. I believe so. Again, this portion of the amendment came from Ms. Kaylee Work. And my understanding is that, yes, it would make things uniform. Perhaps she's here or wants to weigh in, but it would make it easier for the courts. There would be, as I understand it, one template.
And I don't see the Miss Work here. Oh, it looks like somebody from the office. Okay, somebody from the office, I think, is going to testify. Thank you.
I'm phoning a friend.
Good morning, Chair Torres and committee members. My name is Shawneen Guerin, and I'm with Douglas County Recorder's Office, and I've worked very closely with Ms. Kaylee Work on some of these conceptual amendments that we're looking for. And some of the notes that I took along the way, I'd love to be able to provide some clarity on it. First of all, with regard to the multiple properties, the order is written as such. I will speak from the recorder's standpoint. It's very different on the recorder's side than it is, say, on the assessor's side or the clerk's side, where there's a single data set of information that's being marked confidential. On the recorder's side, where the difference lies, is that we are actually affecting individual documents, individual records that are on record. So if you own multiple properties and then within the order, you as the petitioner are required to identify what document numbers are on record that contain specifically the personally identifiable information. Now keep in mind, statute sets forth the personally identifiable information is limited to the personal residence, a phone number, and an email address, and the party names. Statute, we do not redact the party names for the sake, again, that was brought up of transparency in government. You can identify that, yes, Joe Smith owns property in Douglas County, but you don't see the physical address. So we're limited as to the information that we can redact. Then one of the issues that was brought up as far as the expiration of the confidential records, the reason that would be beneficial to be optional, there's a number of reasons that one county might want that option, want to institute that option, and another might not. First and foremost, the sheer volume. In Douglas County, we are understandably going to have much less volume of these types of orders that are put in place than, say, in Clark County. So the ability to manage the volume is something that we don't want it to come across as an unfunded mandate, where we're having to, we can probably manage it on a more manual basis. If you get into the larger volume of records, now you're looking at having to implement software to keep track of things, and it becomes a lot more cumbersome. It can be done, but it will require time and money. So this gives the various offices the ability to work within the scope of what they can work with for expiration. The other, let's see, what was one of the other things? Was there another direct question that you were looking for clarification from the recorder side?
I think the question was regarding the intent on how to make the list uniform.
The list uniform, yes. So as far as the uniformity of the list, there is, as was brought up, a lot of discrepancy between the various statutes and the various offices that are affected. So currently we have 2 different court order templates because not all of the groups that are protected under one statute have the same protection under the other. So there is a desire, however, it needs to be brought about to, at the very least, have uniformity across the different statutes so that we're not having to identify, does this group need this order, does this group need that order, and then within our offices, does this affect our office or not? So whether it's by having, you all have the ability to decide if that is more along the lines of having a general option for people to petition the court regardless of positions held, or whether it's just identifying what positions held are listed in each of the statutes and just bring those into alignment, that would be much appreciated.
Thank you. Is there a follow-up, Assemblyman?
No, I'm good, Chair. Thank you very much, and thank you for the explanation.
You're welcome.
Thank you, members. Any additional questions? Assemblyman, Vice Chair Duran.
Thank you for the information. I was just wondering, what is the process that they have to do? Is there a charge? Is there something, is there a process that you have in place that can be an example for other counties or cities?
Yes, Shawneen Guerin for the record again. We each have processes within our individual offices. They're, again, going to vary between the different offices. So from the assessor's office to the recorder's office, those processes are going to look very different. And then across the different counties, depending on staffing levels and who's responsible for what, the processes might look a little bit different. But essentially, from our standpoint as recorders, there is no fee to redact the records. We receive the order. That order does not get recorded. It just gets filed away so that, obviously, because the order contains that sensitive information. So we keep that in a separate record, and that is not part of the public record, and then we just redact the documents accordingly.
Thank you. And just a follow-up to that, can you talk a little bit about that process to redact information? Is it as easy as like a computer click, or how does that work for you all?
Shawneen Guerin again for the record. For the most part, if I can speak as to Douglas County's records, our records are all digitized, our deeds back to 1853, so 1855. So deeds and records all the way to current are digitized. So yes, for us, I can speak very clearly that it's just a matter of digitally redacting those documents. And there is also a process for removing that redaction, but certain elements, as set forth in statute, have to take place. Certain steps by the party who has petitioned for the court order specifically. So yes, there are processes.
Thank you. I appreciate that. Members, any additional questions? I don't see any additional questions. So at this time, and thank you for coming up as well.
Thank you.
At this time, I'll invite anyone wishing to testify in support for AB 225. Don't see any here in Carson City. In Las Vegas, is there anyone wishing to testify in support for AB 225? BPS, is there anyone on the line wishing to testify in support for AB 225?
Chair, the line is open and working. There's no callers on the line to testify in support at this time.
All right, I'll invite anyone wishing to testify in opposition to AB 225. I don't see any here in Carson City. Is there anyone in Las Vegas wishing to testify in opposition to AB 225? I don't see any in Las Vegas. PPS, is there anyone on the line wishing to testify in opposition to AB 225?
Chair, the line is open and working, but there's no callers on the line to provide opposition at this time.
All right, and at this time, I'll invite anyone wishing to testify neutral to AB 225. Looks like we have a couple people coming up. When you're ready, you may begin.
Hello again, Shawneen Guerin, Douglas County Recorder, and also I did get permission to be speaking on behalf of the Recorders Association of Nevada. The one thing that I didn't mention that I think is important is an understanding of what the final point on the conceptual amendment is shown as. So we are testifying neutral as to the group or any other groups that would be included in the allowance of the courts to issue this type of order. But this is an opportunity mostly just to clarify in that subsequent recording, one of the distinct differences, again, that affects the recorder's offices is you can bring us a court order today, and we will redact the documents that you have set forth on that order. Whether it's one document or 100 documents, we're going to redact those documents. However, if in 2 years you decide to refinance your home, for example, every time you refinance, there's typically 2 to 4 additional documents that are going to record. Currently, there is no mechanism in place that provides for the recorder's office to then redact the personal information from those records. And we wouldn't know. We wouldn't know, especially in the counties that have a larger volume. We don't have any way of keeping track of if it's these properties or these names that are documents are recording. That's not an element that we're looking for as a recordable form. So this would, we're looking for a mechanism for the petitioner to know that they're recording a document or a set of documents, and to then notify the recorder's office that these documents need to be recorded, ideally upon recording, because quite frankly, once the information's out there, it's out there. And we've all come a long way in the name of transparency and efficiency to be able to provide the records in the most timely manner possible. Sometimes it can be a double-edged sword where once it's out there, it's out there. So I just wanted to provide a little bit of clarity as to what the subsequent recording element is. That would be specific to the recorder's office. Thank you.
Good morning, Madam Chair, members of the committee. For the record, Cadence Matievich representing Washoe County. We too are neutral on the policy of the bill with respect to which groups or persons should or should not be covered. I did just want to come forward and thank Assemblywoman Newby for sort of taking on the challenge of addressing all of these procedural and implementation issues that you've heard raised by the recorders and by the courts. We think that irrespective of what you decide on the policy of who should or shouldn't be included, cleaning up these procedural things, making it uniform, will in fact actually achieve what we believe was the intent, provide the protections that was intended by the original legislation and any subsequent legislation that you may pass to include others in this. And so we are very appreciative of her and working on that. There's a number of other bills, and we hope that these changes could be harmonized into those as well. Thank you.
That is definitely the goal. And thank you, Assemblywoman Newby, for all your work on this issue. Is there anyone wishing to testify neutral to AB 225 in Las Vegas? I do not see anyone. BPS, is there anyone on the line wishing to testify neutral to AB 225?
Chair, the line is open and working, but there's no callers choosing to testify neutral at this time.
All right, at this time, I'll invite the bill sponsor for any closing remarks. It doesn't seem that we have any, so we will go ahead and close the hearing on AB 225. And we will go ahead and move on to, and open the hearing on AB 333, which revises provisions governing housing authorities.
Good morning, Chair Torres and committee members. I am B. Duran, representing Assembly District 11 in Clark County. Thank you for the opportunity to present Assembly Bill 333, which revises provisions governing housing. I bring this bill today because your home is your castle. You should be able to live in your house, safe and comfortable, and a place that you should be able to raise your family with dignity and respect, make special memories with your family, friends, and loved ones. A place that you should be proud of, regardless if you own your home, renting an apartment, live in a senior community, or even in a public housing. Regardless where you live, northern Nevada, southern Nevada, in cities as big as Las Vegas, Reno, or as small as Goldfield, Beatty, rural areas, or even in an indigenous community. Your home should be your safe place. I bring this bill for you today because of personal experience. My dad is living in a senior community for a little over 20 years, and his house has never been painted, never had a full inspection of his appliances, never had his sink checked. They never looked under the sink for wood rot. Recently, we complained that his faucets were so full of calcium buildup, we could barely move the faucet from one side to the other side. They did replace that. Most people don't report issues because they don't know how to, or they're afraid of being evicted. With having a housing shortage, these homes and apartments should be taken care of so that the owners and residents have a safe home. And if the owner finds work that needs to be done, or things that need to be replaced or fixed, they can fix the necessary issues in a timely manner, and it won't cost them an arm and a leg to keep their property from being depopulated and becoming inhabitable. There have been many complaints from my constituents about some of their living conditions, and there is nothing in statute to hold owners accountable. These complaints go unheard, and the owners continue to ignore them, and there is not much they can do. Moving is not an option for most of our constituents. They can't afford the cost for deposits, background checks, credit reports, first and last month's rent. I'm going to give you a little background information. And today I have Mindy Elliott, Senior Vice President from Flint Judici, and William Brewer, Executive Director for the Nevada Rural Housing Authority. I'm going to go through some of the background information, maybe walk through the bill a little bit, and then we will be able to answer some questions. So, the background information, housing authorities have a long history in Nevada. While the United States was engaged in World War II, the 1943 Nevada Legislature enacted Assembly Bill 36, known as the Housing Authorities Law of 1943, to aid the prosecution of the war by providing the creation of local agencies to cooperate with the federal government in making housing available for persons engaged in war industries and activities. Specifically, Section 2 of AB 36 authorized creation of housing authorities with this language. Upon the adoption of the resolution by the government body of a city, town, or county that there exists or impedes an acute shortage of housing in such a city or county for persons engaged or to be engaged in war industries or activities. There shall hereby be created a public body corporate which shall be known as the housing authority of such city, town, or county. The statutory provisions related to housing authorities are found in Chapter 315 of the Nevada Revised Statutes, I can't talk this morning, and their services have expanded to meet the needs of a much wider group of people. There are 3 housing authorities in Nevada. Currently, Reno Housing Authority, Nevada Rural Housing Authority, and Southern Nevada Regional Housing Authority. So we're going to walk through the bill right now. Section 1 of Assembly Bill 333 requires each housing authority in the state to contact a person who is 60 years of age or older and has lived in a public housing or housing project that is operated or managed by the housing authority, to offer to perform an inspection of the dwelling at least every 5 years. If the resident wants the inspection performed, the housing authority must conduct such inspection on a day at a time that is convenient for the tenant. The bill further requires such an inspection be conducted to determine whether the dwelling unit of the person is decent, safe, and sanitary conditions, including without limitation that the fixtures, appliances, and plumbing are in good working order. And 2, the housing authority to ensure all necessary repairs are made as soon as practicable and after the inspection to ensure that the dwelling unit is in decent, safe, and sanitary condition. Section 2 relates to unfunded mandates. It provides the statutory requirement for a specified source of additional revenue to pay for an additional expense associated with carrying out the requirements of certain legislation that do not apply to AB 333. So with that, we do have a couple of amendments that aren't ready yet, but I am working with the Housing Authority as well as Mindy over here concerning an issue that had taken the Southern Nevada Regional Housing Authority out of statute in 118, I believe. Or 318? She's going to explain to you, there was an issue that happened some years ago that she provided an amendment for, and she can explain that as well.
So, good morning, Chair Torres and members of the committee. For the record, Mindy Elliott, representing the Southern Nevada Regional Housing Authority, the Reno Housing Authority, and the Nevada Rural Housing Authority. And with me today is Bill Brewer, as Assemblywoman Duran said. First off, we want to thank Assemblywoman Duran for this bill and for our conversations. I'd like to have Mr. Brewer explain some of the requirements that they currently, that the housing authorities are under, because they do receive the federal funds from HUD, and there are some requirements. But I think that the bill, the intent of the bill, is why there's a need for some cleanup, some tweaking. But I'll have Mr. Brewer discuss in detail exactly what they go through with a tenant. Mr. Brewer?
Good morning, Chair Torres and members of the committee. Thank you for this opportunity to visit with you. I'm Bill Brewer, the Executive Director for Nevada Rural Housing Authority. As we've examined this bill and worked with Assemblywoman Duran, we appreciate the intent of this bill, that we need to be looking after our tenants and making sure that they have a decent, safe, and sanitary place to live. In fact, those are the federal guidelines that we operate under. And if a person has a housing choice voucher, we are required as administrators of that program to inspect those units when the person moves in, and then every 2 years thereafter. So the federal requirement is much more stringent than what's proposed in the bill. If a person lives in public housing, we are required to inspect those units every year. And so the federal requirements are quite stringent on that as well. And so if a unit is not being inspected or looked after, that's a problem for the housing authority that needs to be addressed with the housing authority and or with HUD, who oversees that program. And so we certainly support that and encourage that. Beyond that, we should have a standard that really is a little more kind and thoughtful than that. For example, my personal standard is if I wouldn't want my mother to live in that unit, I wouldn't want anybody else to live there either. And that's how we try to manage our properties and manage our voucher units. And we've run into some issues, of course, when you have a number of issues or units out there and a number of tenants. Things are going to happen. We look after those and try to get those corrected as soon as we can. What we run into oftentimes is that tenants are afraid to bring issues to the management of those units for fear that they'll be in trouble, or they just don't want to bother somebody. But you all know, if you've lived in a home and you have a leak under your faucet, under your sink, you're going to damage your cabinets and maybe have much greater damage beyond that. And as a landlord, I personally want to know about that so I can come in and fix that. And so we need our tenants to report those things. If there are other issues with the unit, we need to know that. And so what we're proposing is some kind of a feedback mechanism, perhaps a survey or something such as that. So when these tenants renew their certification each year, they have to come in each year and renew their income certification to make sure they're eligible for those units, to have a questionnaire there for them so that they can report any problems that they may be having with the unit. And that way it gives us a mechanism to follow up on that and make any needed repairs to that unit at that time. So we're working with Assemblywoman Duran on that, and we hope to have that in place before you see the bill again.
And thank you. And once again, we did have another amendment that was working with Make the Road as well, and they proposed something like that. So we did check with legal, and they are getting something together concerning that too. We can continue working with the Housing Authority to make sure that that's something that was doable for them as well.
And thank you, Mr. Burr, and thank you, Assemblywoman Duran. And again, for the record, Mindy Elliott with Flynn Judici Government Affairs. DPS, I have on the phone Mr. Theodore Parker. He's a managing partner with Parker Nelson Associates, and Miss Mahogany Turfley, partner, who's a partner, and they are on the line and can provide the context to the purpose of the next amendment if.
Thank you. And Ms. Elliott, so I have, we did flag for BPS Mahogany Turfley, and is she in the same room as the other individual?
Yes.
Okay, they're together.
They're all together.
Okay.
Thank you, Madam Chair.
Thank you. BPS, if we could have them come on the line.
And they are going to discuss the amendment regarding removing the Southern Nevada Regional Housing Authority from NRS 354.474. We'll just be deleting that section of NRS. And the reason. For the record, Mindy Elliott.
Hello. Can you hear me? For the record, Mahogany Turfley, Parker Nelson and Associates. I also have Mr. Theodore Parker. Mr.
Yes.
Parker.
Yes, we can hear you. Please
Yes,
proceed.
I'm on the line. Good morning. Sure. This is Theodore Parker as well on the line from Parker Nelson. Good morning. And thanks for giving us some time to explain from the Southern Nevada Regional Housing Authority's perspective why this amendment would be appropriate. For some reason, the Southern Nevada Regional Housing Authority was excluded from 354.474 initially. And when it came to our attention, of course, we wanted to get it addressed. The main reason is the Southern Nevada Regional Housing Authority, not unlike the Rural Housing Authority and the Reno Housing Authority, are all funded by the federal government, by HUD. And as a result, the Code of Federal Regulations require that we internally audit ourselves, that we pay for an independent third-party CPA firm to audit our finances, and then HUD audits our finances, all in accordance with the federal regulations. And so that is the main reason why having Southern Nevada Regional Housing Authority comply with a state statute related to auditing and our year-end financial information does not coincide with the federal year-end requirements and auditing requirements that we have. Again, we don't receive any state funding, no state tax dollars. All of our dollars are federal money. Our year-end is consistent with the federal regulations as opposed to what the state does. So again, that would put a greater financial burden on the Southern Nevada Regional Housing Authority that no other housing authority in the state has to comply with. And so we want the Southern Nevada Regional Housing Authority, not unlike, again, the Rural Housing Authority and Reno Housing Authority, to not be a part of this requirement under 354.474. Given the heightened amount of evaluations and scrutinization that we get by the federal government for all of our financial expenditures. The other concern that we wanted to express is that in addition to all of the accounting that we pay for, third party, our own internal, as well as accommodating HUD auditing, we also, the cost of doing anything additional interrupts what we have to do for HUD, and it's an expense that otherwise would go towards providing additional housing. So that's a concern. And then finally, the information we provide to the state, it's difficult to determine how useful it is for the state because we're providing information that complies with the federal regulations, and it's not consistent with what the state typically would do because the state, of course, is concerned with its tax dollars and how its political subdivisions are spending and accounting for those dollars, which is different from the federal regulations. And so hopefully that helps give context to why we would like this amendment made. If you have any questions, I'm more than happy to address.
Thank you. At this time, is there any additional remarks? No, at this time, we'll go ahead and open it up for any questions from committee members. I have Assemblyman Nguyen.
Thank you, Madam Chair, and thank you, Vice Chair Duran, for this presentation on this bill. I was just wondering, and I think I've asked this question before in another committee, and I want to make sure that we follow up with this. In terms of age selection, you selected 60 years of age. In terms of funding and opportunities to get federal dollars and other grant that might be there, I think the elderly person in the federal statute are categorized at 62 and older. So I'm just trying to figure out, if we put 60s, do we limit ourselves from some additional funding opportunity that could help this project? Thank you.
Thank you for that question, Assemblywoman B. Duran. So this was a personal experience that I had personally with my family and my father. So after I was talking about it and doing that, I know we can modify the age groups. Hopefully, this just opens up conversation throughout. It's not just the seniors that have this. We have a shortage in our state, all over the country. So I'm thinking that hopefully this opens up the conversation for everybody, not only seniors. We have people that are in public housing and just people that rent, to be able to have the opportunity to live in a safe and decent place. So that was my thought process as we moved on, and the language drops. We get more people coming forward, stakeholders coming forward as well. So I think we can modify a lot of the language, and with the funding part of that, that's a whole different animal that we have to address as well. If you have anything to add.
Hi, Bill Brewer, for the record. You're correct, Assemblyman. The federal line in the sand is 62 years of age. The way this bill, though, is written, I don't think it would have any adverse effect on that kind of funding, as the bill doesn't really address funding. It addresses really the physical condition of the units.
Thank you for that. Thank you, Vice Chair, for the answer. I just want to make sure that we don't leave any money on the table if we are eligible for that. So I look forward to working with Madam Vice Chair and all of you in terms of ensuring that if this does pass, that we include elements that would help us to get those additional dollars to help this project, because I think it's truly needed and many people would benefit from it. Thank you, Chair.
Thank you. And I see Assemblyman Koenig next. Members, if you had a question, could you please raise your hand? I lost my little sticky note. Okay, perfect. Thank you. I'm going to go to Koenig next, and then I'll go to Assemblyman Taylor.
Thank you, Madam Chair. So I just need a little clarity so this applies to projects operated by the Housing Authority. Now, when you were talking about one group is already required federally to inspect every 2 years, and another group is already required federally to inspect every 1 year. That's not the Housing Authority. This is someone completely different. And then my second question is, I think we just heard on the phone where we want to exclude the Southern Housing Authority. What exactly is included in that, and who are we excluding by excluding that? What's left after we take that out of the picture?
For the record, Mindy Elliott, so let me address the amendment. So all of the housing authorities are governed in NRS 315, all of them, whether it's Reno, Southern Nevada, rural, they're all under 315. The amendment, there was an amendment that was put forth in 2017, I believe, that provided some additional requirements on the Southern Nevada Regional Housing Authority specifically. The other two housing authorities were not required to provide the additional information to the state. The issue with the Southern Nevada Regional Housing Authority, I'll talk to the amendment first. The issue with NRS 354 placing the Southern Nevada Regional Housing Authority, it's still in NRS 315, they're still there, but it also placed them in NRS 354 for oversight from the state. The issue with the oversight from the state is that the housing authorities receive all their funding from the federal government, therefore their timing for their financial statements and those requirements aren't in sync with what the state requires and the timing of the state. The state has a fiscal year ending June 30th. The federal government has a fiscal year ending September 30th. So there was a disconnect on not only the timing, but the what the Southern Nevada Regional Housing Authority is required to report to HUD, there's a disconnect with the state. For the purpose for the 2017 amendment, I hope I'm right on my calendar date.
Just Ms. Elliott, just so you know, it's from SB 183 of the 2017 cycle.
Well, I had thank you so much thank you, Madam Chair, and for the record, Mindy Elliott, for the record. The purpose is no longer, it doesn't make any sense to have that requirement. That's why this amendment has been requested, just so that it doesn't remove any of the other requirements that the state has on the Southern Nevada Regional Housing Authority. They're still in 315. There's still public notice requirements. None of that changes. The only requirement that changes is that they're the financial requirements that are reporting requirements to the state, because it just doesn't make sense. It never made sense. I don't know why the amendment was made, but we appreciate Assemblywoman Duran. We've had several conversations with her and Senator Neal and several other Assembly and senators as it relates to having this requirement removed. It's redundant, frankly. So we appreciate having the opportunity to bring forth this amendment to remove that requirement. I do want to make it very clear, though, it doesn't change anything as it relates to their responsibility to the state under NRS 315. And then your second part of your question, I'll defer to Mr. Brewer. Thank you.
Hi, Bill Brewer, for the record. Thank you for the question. There are three kind of fundamental types of vouchers that we're talking about. There's the housing choice voucher, which is issued to an individual, and that individual can take that voucher and rent an apartment anywhere they choose that fits the requirements for the voucher. Then there are project-based vouchers, which is essentially the same as the other kind of voucher, except it's assigned to a project, not to a particular person. And so a person moving into that project theoretically could take advantage of that voucher and have their payments subsidized. And then thirdly is public housing, which is funded completely separately under federal budget requirements, and those have a different set of rules altogether than the vouchers. So as housing authorities, we cover all three of those, although Nevada Rural doesn't have any public housing. But that's where those inspection requirements come in. So for all housing choice vouchers, whether my client is renting an apartment from you or from us or anybody else, we have to inspect those units every 2 years. And for the public housing, then we have to inspect those each year under the guidelines of the federal government.
Quick follow-up, if I may.
Go ahead.
So then, the 5 years would be under the housing authority. So what kind of units are under the housing authority that would be affected by this every 5-year inspection?
Assemblywoman Duran. So before I really checked into this, it was just something, unfortunately, I knew there was some rules. Those aren't happening. So I'm trying to just put something in place to where even if it's private owners that are having, renting long-term to long-term people, that they can be able to have something to say, hey, that's just a starting point. I wanted to open up the conversation. I'm willing to go through any amendments. Unfortunately, I knew there was rules, but those rules aren't happening. We have to have something in place to be able to do that with the housing authority, the federal government, with HUD. But also landlords. Landlords don't come in. They rent a house, they're living in California, and they're just collecting their rent. Who's going to come in and inspect the house and to be able to do that? It's something that people my constituents have made complaints to myself that they're living in roach-infested housing in units or in apartments, even houses, and there's nothing that can be done. So, but to move, and the cost of moving somewhere is impossible with everything else.
I'm sorry for dominating this.
Talkative today in this committee. Go ahead, Assemblyman Koenig.
One last question. So, I mean, the bill says housing project that is operated or managed by a housing authority. Now, as a private landlord would fall under, operating under the housing authority?
B. Duran for the record. My goal is to have not only the housing authority, it could be somewhere else and they're not listing that. We just want to make it clear that we need to hold homeowners that are renting properties out and collecting money. People need to live in dignity and respect, and I think this is a starting point. It may not be under the housing authority, it may be under a lease renewal to have a questionnaire to do that. So I think that's why we're going to be working with stakeholders and other people to kind of amend the bill a little.
Thank you.
And I did have a quick follow-up question to that point. My understanding too is there's federal requirements on what those houses have to have too. So if somebody is a landlord, they're supposed to be meeting this requirement. So this would just be ensuring that those landlords that are already participating in this program, by having tenants that are a part of this program, that they're meeting those minimal standards, correct?
For the record, Mindy Elliott, and Assemblyman Koenig, thank you so much for your question and the follow-up, Madam Chair. So the amendment that we're in discussion with our very passionate Assemblywoman Duran is going to look like it'll be a certification on either an annual basis, or we're in the process of looking at that, either a annual basis or biannual basis, and it'll be between the tenant and the landlord, and it'll make sure that there'll be a checklist that, how is everything looking, how's it going? And as Mr. Brewer alluded to, the concern is that maybe tenants don't feel as comfortable to go. If I'm the landlord, they don't feel as comfortable, and I'm renting to someone that has a housing choice voucher. I'm not under the umbrella of the Nevada Rural Housing. I'm not an employee of Nevada Rural Housing, but I'm an independent landlord, but I'm renting to somebody. That will require me as a landlord to work with that tenant to make sure that there's a checklist. So that's what the conceptual amendment is going to probably do, and we're in the process of finalizing that. So it'll be a little different. Do we think that there's a need for this? We think this is a good idea. And so we are more than happy to work with Assemblywoman Duran to make sure that this amendment meets the goals of this bill.
Thank you. I have next Assemblyman Taylor, then Assemblyman Thomas, then Assemblyman DeLong.
Thank you, Madam Chair, and thank you, Assemblywoman, and others who are here, the presenters. I do think this is absolutely necessary, and I can see a lot of sides of this. My mom lives with me, so we don't have to deal with that. But my grandmother lived in a very different situation, and she lived in a place, this was in California. She was there for probably 30 years, but was really afraid to advocate for herself because, we know how it is in California and the rents and so on can be. So finally, we just moved her out. But I've seen older people in particular be taken advantage of in this situation. And I happen to have a rental house, so I see the other piece of this as well. So I just want to make sure I'm glad I'm after my colleague, Assemblyman Koenig, because I want to make sure, so I kind of have my arms around this a little bit. So it's already in federal law, really, 1 year or 2 years, depending upon what kind of housing it is. But we know it isn't always happening. And the whole idea behind this is to ensure that it happens and take some of the pressure, if you will, off of that renter that may be in a tough situation because they don't want to be, especially we know how rents are in Nevada right now anyway, especially in our part of the country. And so this would extend in particular towards those that are in the housing authorities. In addition, there may be those who may have Section 8 housing, which may be private property owners who rent that way. They would still have to do the 1 year, because it's not a housing authority thing, but they would have to have the inspections at least every 5 years to take advantage of that. I don't know how it will reach to, say, someone like myself. My tenant is not in Section 8. I don't know how, I'm fine with that, right? I don't know how that piece might look because there's no connection there. That might be a little bit more individual, but at least for those who are doing some kind of public housing service, authority or personally because they're getting the Section 8 voucher, would have to fall under this, except for in Southern Nevada. Now, in Southern Nevada, they're different. Well, that's a whole different conversation. But for housing, they're different, right? And so in some, they're not different. They have to follow this thing, but they won't be in this because they have a separate legislation that was passed in 2017. If you can clear that piece. I was doing so well. I thought I had it.
For the record, Mindy Elliott, you were doing awesome. Through you, Madam Chair, to Assemblywoman Taylor. You were doing great. the Southern Nevada Regional Housing Authority, I want to make it abundantly clear, they are still under the same requirements of every other housing authority. The only thing that the amendment will do will eliminate the requirement for the Southern Nevada Regional Housing Authority to give their financial statements to the state. That's it. But the rest of the requirements under NRS 315 for the Southern Nevada Regional Housing Authority remain the same. So whatever the Nevada Rural Housing Authority is required to do, Southern Nevada Regional Housing Authority will be required to do. Public notices, everything else is still a very robust requirement by the state of Nevada in order for them to operate under NRS 315 remains the same.
Just one quick clarification, if I may. Madam
Go
Chair,
ahead.
thank you. So they would not be a part, though, of AB 333?
For the record, Mindy Elliott, through you, Madam Chair, to Assemblywoman Taylor, they are absolutely required.
They are still, okay.
Every single under this bill, anyone that is under NRS 315 will be required to.
Got it.
Once this certification or whatever is developed, they will be required to perform.
Got it. No, it's very clear now. Thank you very much. Thank you for helping to get me through that. Madam Chair, thank you for your indulgence.
Thank you. And my understanding from SB 183 from our earlier conversations, because we did have the opportunity to meet before the hearing, is that in reading through SB 183 was very unique in that it only applied to the Southern Nevada Housing Authority. So it would just make the Southern Nevada Housing Authority consistent with the reporting requirements that are currently applicable to the Rural Housing Authority and I guess the Northern Nevada Housing Authority, might have a different name, but to the other agencies where the Southern Nevada Housing Authority is required to submit additional reporting. Is that correct?
Through you, Madam Chair, Mindy Elliott, for the record, that is correct. Whatever the other two, Reno Housing Authority and the Nevada Rural Housing Authority, whatever the requirements are under 315, the Southern Nevada Regional Housing Authority will still have those requirements.
Thank you, perfect. And then all the housing authorities obviously would still be required to follow this bill, AB 333. I do know I have a couple additional questions from Assemblywoman Thomas. Go ahead.
Thank you, Madam Chair, and thank you for the presentation. I do appreciate it. And actually, my colleagues have asked, and you've answered the questions that I was concerned with. And it looks like this bill will have the tentacles to reach not only the housing authority, but the rental associations, anybody that has property that they're renting. So, because I believe everyone needs the bare necessities in life.
Thank you, Assemblywoman Thomas. Assemblyman DeLong.
Thank you, Madam Chair. Just want to get this clear. I think I'm confused on a couple things, or maybe I just didn't hear correctly. And it's basically from the Assemblywoman's response to a comment. Are all landlord-tenant contracts subject to this law, or is it only those covered by the Housing Authority?
B. Duran, to Mr. DeLong, thank you for the question. So I would like to start there, but again, we have landlords again. Hopefully, this bill would require that. Hopefully, it builds that bridge to have that communication open, that you can deal with your landlord and be able to call them up and say, I have an issue, or come and check my plan. Now, I think the public housings that we do have, and I would hope any landlord, if I owned a property, I would love to go in there and to be able to fix something, not just to do an inspection every couple of years if there is nothing wrong, to be able to make sure that things are in working order, because you don't want to go in and have a bigger cost when it can be fixed quickly. Or if there's a water leak, you want to be able to fix that leak, and instead of have rot everywhere. So to me, this is a start, but hopefully it would expand to private landlords as well.
Thank you. And I'm going to go ahead and go to Asher Killian, our legal counsel.
Thank you, Madam Chair. Asher Killian, Community Council. And yes, just in response to that question, the bill as introduced only concerns housing that's operated or managed by a housing authority.
Thank you.
Thank you. Assemblyman Hibbets.
Thank you, Chair. And my question is probably better answered by Mr. Killian also, so please take a breath, relax. Mr. Killian, the Section 2, the provisions of NRS 354599 do not apply, and I'll skip to the end, to the provisions of this act. Why not?
Thank you, Madam Chair. Asher Killian, Community Council. So I can't make a policy argument as to the why. What I can say is that that section of law generally requires some sort of funding stream to be provided when a bill would impose an obligation on a local government. What Section 2 does is exempt the provisions of this bill from providing that kind of funding. As to why, that's a policy question that I wouldn't be able to answer.
Quick follow-up for just my own edification. In reading 354599, it seems to me that it basically says, and I'm going to paraphrase because I don't have my computer open at the moment, basically says that any law passed by this body that requires a new or expanding service by a local government has to have an identified funding source. I didn't see anywhere in 354599 where you can exempt something or say, nah, we're not going to do that. Am I correct in my assumption?
Thank you, Madam Chair. Asher Killian, Committee Council. So NRS 354599 is a provision of law that was enacted by a previous legislature that expresses that policy. Generally, constitutionally, no previous legislature has the power to tie the hands of the current legislature, just as the current legislature has no power to tie the hands of a future legislature. So while NRS 354599 was a law adopted by a previous legislature, the current legislature retains the power to either exempt any particular piece of legislation from that provision or to repeal it entirely.
Thank you very much. I appreciate your time.
And upon review too of the fiscal notes posted on us, there are no fiscal notes on this bill at this time. All right, members, any additional questions? Seems like almost everyone's asked a question today. Solomon MacArthur, you feel left out? No, it looks like we're good. All right, at this time, I'll go ahead and invite anyone wishing to testify in support to AB 333.
Hello, Chair, members of the committee. Tony Ramirez for the record, T-O-N-Y-R-A-M-I-R-E-Z. We are in support of the intent behind AB 333. In particular, we are here in support of the language we have been working on with stakeholders and the Assemblywoman to capture all vulnerable members of the community and require all landlords to keep their dwellings habitable and livable. We feel it will also provide protections for tenants who proceed to withhold rent with a survey response serving as official notice for repair. We have been working closely with the Assemblywoman. We're deeply grateful for that, and we hope to continue doing so. Thank you. Bye-bye.
Thank you. I don't see anyone else wishing to testify in support of AB 333 here in Carson City. In Las Vegas, is there anyone wishing to testify in support of AB 333? Doesn't appear so. BPS, is there anyone on the line wishing to testify in support of AB 333?
Callers, if you would like to testify in support of AB 333, please press star 9 now to take your place in the queue. One moment, Chair.
Hello, Chair, members of the committee. My name is Andy Romero. That's A-N-D-Y-R-O-M-E-R-O for the record. I'm here representing Make the Road Nevada. We are in strong support for the intent behind AB 333. As the housing organizer in Nevada, I've seen some poorly conditioned units that tenants have been subject to by their bad landlords. The reality is tenants are in fear of being evicted if they pressure their landlords in fixing their unit's concerns, leaving them vulnerable and with certain health risks. The intent of AB 333, which seeks to hold the bad landlords accountable by requiring them to respond to the tenants' complaints in a timely manner, and also requiring them to repair the unit, make it livable, will be so much help. The tenants of Las Vegas are grateful for the Assemblywoman Duran, who has allowed us to work very closely with her to this bill. We hope to continue working with Duran and share capital to capture the vulnerable members of Nevada. Thank you.
Chair, there are no more callers choosing to provide support testimony at this time.
All right, at this time, I'll invite anyone wishing to testify in opposition to AB 333. I don't see any here in Carson City. In Las Vegas, is there anyone? Doesn't appear so. BPS, is there anyone on the line wishing to testify in opposition to AB 333?
Chair, the line is open and working, but there's no callers choosing to testify in opposition at this time.
All right, is there anyone wishing to testify neutral to AB 333? I don't see any in Carson City or in Las Vegas. BPS, is there anyone on the line wishing to testify neutral to AB 333?
Chair, the line is open and working, but there's no callers choosing to testify neutral at this time.
All right, at this time, I'll invite the bill sponsor for any closing remarks.
Thank you for everybody that listened to this bill. I think this is going to help our communities out. I know we have constituents that have some issues going on in their homes, and they need to be taken care of. You know, this affects their family life. The children have issues of going to school when you have somebody that's not taking care of roaches, and they're embarrassed, and they have to live out of bags and can't use their kitchen. It's a problem, and it breaks my heart. So I'm just hoping that we can work on this, probably to make it even better, and thank you. And I hope and urge your support for AB 333. This bill will improve the living conditions of everybody. Thank you.
Thank you, Vice Chair Duran. Thank you for bringing forth this piece of legislation. I'll look forward to working with you on the amendment for this bill. At this time, I will go ahead and close the hearing on AB 333. And that does conclude our agenda for today, so we will go ahead and move on to public comment. Anyone wishing to testify in public comment may testify for up to 2 minutes. Is there anyone wishing to testify in public comment here in Carson City? It does not appear so. In Las Vegas, BPS, is there anyone on the line wishing to testify in public comment?
Chair, the line is open and working, but there is no callers choosing to provide public comment at this time.
All right, thank you. At this time, we'll, just a couple reminders for the committee. Tomorrow we'll be meeting in room 4100, our favorite room, and we will be hearing AB 305 as well as AB 377. Additionally, we will have a work session on 9 bills, I believe. It might be more. I don't remember anymore. But we will have a work session tomorrow on some bills. Please make sure you review that. The work session doc should be posted shortly. Is there any other additional comments? MacArthur minute today? Well, I think it's important that the committee knows, you know, I was speaking to Assemblyman MacArthur, my best friend, this morning, and he let me know that his favorite movie is, do I have any guesses for Assemblyman MacArthur's favorite movie? James Bond. He's a 007 fan. I think that was important to be noted. At this time, we will go ahead and adjourn. Thank you.